Can we talk?
Can we talk?
Can we talk?
¿Podemos hablar?
Can we talk?
All right, well, welcome back, everybody, to the Can We Talk podcast by the Colorado River Regional Crisis Services. My name is Lily. I'm the Community Outreach Educator, and we have a few guests with us today.
Hello, my name is Ashley Stewart. I work here as a case manager and the legal lay advocate. It's good to be here.
And we have a guest with us today.
I'm Sergeant Gomez from the Parker Police Department.
Awesome. Well, today we're going to be talking about orders of protection, injunction against harassment, and some of the things that go along with all of that. So just to start us off, Ashley or Sergeant Gomez, what is an order of protection?
An order of protection is basically a court order that tells another party that they cannot contact this person in certain circumstances or in certain ways.
What is an injunction against harassment?
An injunction against harassment is basically the same thing. The difference is that an order of protection has to meet certain requirements, certain relationships to even have an order of protection, which is basically family, intimate relationships, close relationships, domestic violence, something like that, compared to an injunction against harassment, which is somebody who's not close to you or in a relationship with you, but they're having a lot of harassment or stalking, or there's been sexual violence. There's something that's been going on that has to have the injunction against harassment placed.
Okay, so can either injunction against harassment or OOP or order of protection, can those be put into place for stuff like technology, if someone's harassing through technology, or is it just in person?
It can be through technology also. You have to really show where the harassment's coming from. It has to be really on point, and you have to be able to name that person who is harassing you through those electronic means. So you can't have, I'm getting this phone number, they're texting multiple times. The court is going to ask who exactly is texting you, what is going on, and if it's from different numbers, they can't really prove that it's from the same person. So technically, it's just a spam at that point. But if you can prove and show that this person on social media, this is their name, they keep texting or they keep messaging through social media, Facebook Messenger, Snapchat, certain stuff like that, that shows that harassment is happening, that you know who the party is and you can file that at any time.
Yeah, just to go on that a little bit, we like to tell people too, especially with injunctions, it's better to start the documentation process, meaning keeping your own documentation of it, getting law enforcement involved, or just starting your own kind of paper trail with it. Because the more you have to bring to the court with you when you actually file for your petition, the better it looks for you. And sometimes people think, well, it's tedious that, I don't want to bother you guys. I don't want to call you guys for this, or they feel like calling us is wasting our time, and it's really not, because when it comes to stuff like injunctions against harassment, we want you to be safer than sorry. So even if you call just to say, hey, I'm getting texts or I'm getting phone calls and I think this is who it could be, but can you just start some sort of documentation for me? That's huge, especially when you go to the court and to file your petition, you go to the court and you've got 6 or 7, 3 or 4, however many police report numbers, and they're all information reports. It's not like, we're not diving into your personal life too deep. We're just, giving what you're going to tell us. But the more you have to show for what's going on and you take it to the court with you, it looks better in your case. So even when you think it's not that big of a deal, or you don't want to feel like you're bothering law enforcement with it, by all means, call us. We'll file a report. It's, no waste of our time. We would rather you be safe than sorry and actually be able to get the injunction or the order, depending on, the circumstances and what you're dealing with. So
you guys are able to take information for them. I know a lot of the times the clients will handwrite out incidents that are happening so they can call you, and you guys will also keep a log of incidents?
Yes, we will. And like I was explaining, if they call and say, hey, I've got these 3 or 4 texts from this random number, I don't know who it is, I don't know what's going on, or if they know who it is, they can say, this person's been bothering me, I've asked them to stop, they're still not stopping. At that point, that just not only helps us out, because if we're going to go towards the criminal aspect with it, it helps us show that there's a pattern of harassment here, or stalking, or whatever it is. And not only that, but it also like I was explaining, helps their case when it comes to going and actually getting the petition and filing it, and the judge looking into it more, and then more than likely granting it based on their, list of incidents and proof.
Okay, so keeping an incident list is important.
Yes.
How would somebody go about the process of getting an order of protection?
To get an order of protection, there's two ways. First is that you go to the court. There's paperwork there that you can go ahead and ask for, and you can just get it there. It's free, and then you fill it out there. There's also another way is going on to a website called AZ Point, and you can go ahead and file online there. Each are free. The only thing is when you start filling those things out, you have to be really descriptive of what they're asking. You have to be really on point of answering these questions. And then once you fill out all of these information, which will ask you your information, your date of birth, your address, your phone number, and then they'll also ask about the other party, and they'll ask about their address, their phone number, their information, even their height, their weight. And then you go ahead and mark what's been happening. So there's questions on the petition that will ask you, what's the relationship? And you can mark more than one. What's been going on? There's going to be part for you to write in the incidents, and you talk about what's been happening. Make sure that I usually tell everybody at least 3 incidents that have been happening to show that there's a pattern. In these incidents, you want to make sure that you have a what, when, where, why, and then also explain how you're feeling about this, because order of protections and injunctions against harassment, you want to show the judge how this is affecting your life. How is this affecting you yourself? Are you feeling threatened? Are you feeling afraid? What's going on for you to get this injunction against harassment? And if you call the police, what was going on in that whole situation too?
So have a lot of details when you're doing it.
Yeah, it would be great to have a lot of details put into this whole situation and all of these incidents, because once you go ahead and turn the paperwork in, or you finish up on AZ Point, you have to go back to the courts, and then they'll print out the paperwork, have you sign right there and then and there, and you have to go in person because you want to make sure that you, the person who made the petition, will sign for the petition. And then you go in front of the judge, and the judge will go ahead and speak to you. They'll talk to you and ask you questions about the petition. So they'll try to get more in depth. And from there, it's up to the judge themselves if they want to grant it, or if they don't want to grant it. It's just depends on that information.
So I know that somebody, if they're trying to get an order of protection, can come into our office and get assistance with filling that out.
Yes.
Are they able to go to the police department and get assistance with that?
Yeah, they can come by the PD, and we can talk to them and kind of explain the process of it. We'll actually do the same thing on calls. If we get a call for harassment, a lot of times we'll show up and they'll say, this has been going on for this long, whether it be a week, 2 weeks, a month, 6 months. And normally people will still have the proof. And a lot of times we encourage people to take screenshots of messages, write down dates and times, phone numbers, all that stuff, just so that it goes into that detail, kind of like she was talking about with needing to know like when it happened, what day, what time. Because again, the more information we have to document, the better it looks when you go to the court to actually file for your petition, and the judge looks at it and says, okay, well, we got these 3 reports from the police department, and in these 3 reports it shows the dates and times that this happened. There's screenshots of the messages, whatever it is that they have. It just goes again towards their case to help them out.
When would the order go into effect? What does that process look like?
So the order will go into effect once the judge signs it. The order is made, but the thing is that the other party has to know about it.
The defendant,
yes,
has to be served in order for it to go into effect.
Into fully effect. So even if it's signed in front of it, that's not the end of the whole process. Even if you go in front of the judge, you talk to them and they say, well, I'll grant the order, and she'll sign it in front of you, it's still not technically in effect. It's still not technically gonna be able to be enforceable until it's served to the other party. So once the judge signs it, it'll be sent to a law enforcement agency. Usually in Parker, it goes to the sheriffs and their civil unit, and they go ahead and they'll serve it to the other party or the defendant at wherever location that you put down, or you told the law enforcement where they're at, they'll go ahead and serve it. Once it's given to them and law enforcement reports back to the courts that it was given to them, that's when the order will go into effect.
So what if they can't find the defendant to serve them? Like, let's say the defendant is on the run or couch surfing, or, you know, they can't find the defendant to serve it.
Sometimes the sheriffs will go ahead and ask, you know, if you don't have this address, do you know where they would be, what location where they would, you know, work at, friends, family, some place that they can figure out or they can go ahead and go to. The only thing is that you have to be very accurate on your information exactly where the defendant is, because the sheriffs, the law enforcement, Parker PD, they're very busy, so they don't have a lot of time to hunt down this single person. Usually it's up to the law enforcement how they want to go ahead and do that, but we try to keep them up to date of exactly where that other party would be. And even if they don't serve it, it'll still be in their system. And they find that defendant, and if they pull them over for something else, or they find him for something else, and they can look up their name, that they'll see that order and they can serve them right then and there. Even if your order is not served immediately, just know that it's still in the system.
How long is it in the system for?
I've had one in forever almost. It's been like a year since I've had this order protection I've been working on, and it's still in their system.
But they haven't served it?
But they haven't served it. They'll let you know. AZ Point, if you go through AZ Point, they'll go ahead and email the client, and they'll go ahead and let them know. This agency, usually La Paz Sheriffs, they'll let you know La Paz Sheriff still has your petition. It's still waiting to be served. And a lot of times if you ask law enforcement to look up that petition or look up that information, they have it on their system too.
So does the client or the victim get notified when it is served, or do they just kind of have to hope that, you know, if the defendant contacts them again and they call law enforcement that it's served before that point, or will they be notified?
It depends. We have sometimes that the sheriffs they'll be on it and they'll let us know, they'll call us, or especially if I'm working with them, they'll call me and be like, okay, I served it. Or they'll try to let the courts know that they served it, and the courts will try to let us know, the client know, that it got served. But a lot of times I really encourage everybody to go ahead and keep up with that information and keep up with the petition and keep up with the law enforcement about the service process, because it's very busy for everybody. So it's best just for the client to go ahead and look that information up, or contact that person, or contact us so we can help figure out what's going on.
Can the petitioner serve the defendant, or how is anybody else able to serve the defendant, or who is law enforcement the only agency able to serve?
When we have to have the papers served, law enforcement is usually the ones that we have them serve that paperwork. It's a dangerous situation, especially with domestic violence. If we're talking about domestic violence or sexual violence or any type of harassment or stalking, usually law enforcement is the best bet to go ahead and have that served.
Order of protection, there's no fee for it to be served?
No, there's no fee for order of protection. There's also no fee if an injunction against harassment is marked as sexual assault.
Got it.
But if it's just a regular injunction against harassment, you do have to pay a fee.
Okay.
There's also other people who are like kind of licensed or certified to go ahead and serve paperwork, but you have to look for them and find their services. But usually we recommend law enforcement to do the services and to hand out those paperwork. You yourself are not qualified to go ahead and turn that in,
especially because going into like having the person try and serve it, you don't know what kind of environment they're going to be in, what they're stepping into, like she was explaining, or how volatile the relationship was, and the potential for retaliation when someone gets an order of protection. The first thing they really do is they're like, if it's domestic violence, I've seen where the defendant just gets irate and upset and is wanting to even contact the petitioner even more now, because they're, why are you doing this to me? Why did you do this? Why are you putting in an injunction against me? Why'd you get an order of protection? And they'll try and use the grip they have on people, because in relationships you do see that one person or the other has some sort of power over the other, and sometimes being put back in that situation, people can give into it and it's hard for them to break that cycle and get out of that trend that they've been stuck in for so long, that you don't want to try and put them in a situation to where they could fall back into that pattern or fall back into that cycle that they were trying to get out of and get help with,
Obviously, we're in a pretty small town and everybody knows everybody. So let's say we have a victim and a client that is related or is trying to get an OOP injunction against obviously someone else who's in the community. Are they able to go to, submit a petition, let's say to Yuma County, because they don't want, let's say, their cousin or brother or whoever else is working in law enforcement to serve the defendant? Is that a possibility to go outside of the county to get the order, or do they have to go through our area?
So that's going to be very difficult. If the person is in our community and they're trying to serve somebody in our community, it will go to law enforcement usually, and they'll have that in their system. It's going to be in their system. If people want to look that up, it's going to be in their system. They can go ahead and go to Yuma, but usually they're going to have to drive over to Yuma and then go submit that in person, because you have to sign in person for those orders, and they have to explain the situation, stuff like that. And then when it gets served, they can say, I don't feel comfortable with the county law enforcement or the town law enforcement to serve this paperwork. Can I go ahead and have my own certified processor to go ahead and serve that paperwork? They can try it that way to be safer, but technically they're still going to have that in the system, especially in Paz County, because they're going to have to be notified of an ongoing order of protection that is valid right now.
And this order of protection, they get it in Paz County. Is it valid all through across the state, or do they have to get it in every county? Let's say our victim and client is traveling to Flagstaff and they're worried about the defendant following them there. Do they have to, go to Flagstaff and get another OOP, or is it valid across the state?
Once you get an order of protection, you have it, it's valid. Everybody in Arizona, law enforcement, courts, they have to enforce it, and usually they do enforce it just due to good faith. They'll enforce those orders because it's written from a court. They'll do that. They don't have to go to La Paz or Mojave or Flagstaff or Coconino or whatever. They don't have to go ahead and do it all over again. They just have to take that order with them and make sure that it's, correctly served to the other party and it's valid. And they can take it anywhere in Arizona and have it with them at any time. So they just have to show law enforcement, and law enforcement will go ahead and enforce it.
So how does that work with tribal law enforcement as well? Since we're on the reservation, how do they have to get a separate OOP for the defendant, or the victim is Native American? How does that work?
Since the jurisdictions are a little bit different, if, let's say, I am here getting up here on Justice Court, I'll go ahead and get an order of protection. Once I get that order of protection, I need it served down in Crit lands.
So do they have to apply again?
Yes. So they'll have to take that order of protection that they got from Justice Court. They'll have to take it to the tribal court. And from the tribal court, they'll have to go ahead and fill out some extra paperwork with that order of protection that they got. And it gets sent to their head judge. Then the judge there will go ahead and review it. And he will determine if he wants it domesticated or not. From there, if he does approve it and he's okay with it being domesticated, it'll go to their law enforcement, and law enforcement will go ahead and enforce that order and serve it to him or her.
So on the law enforcement side of this, let's say there's a tribal order of protection, but not one through the county. Will you guys still honor that order of protection?
We haven't run into that issue since I've been here in the last 7 years, and I've never seen it actually come up. So I couldn't give you an answer and fully be confident with it, just to be 100% with you and real and straightforward. But if that were to happen, I would more than likely contact the courts and verify with them. I would contact the courts here in town and let them know there's an OP on file. It's through the tribal court. However, this is the situation I'm at. This is a tribal victim, and I have a tribal suspect, which in those cases where we have a tribal victim and a non-tribal suspect will normally take primary on those cases. So as long as everything lines up and all the information is in front of us and we can verify what's going on, we will act on it and make sure that, one, the person is protected, and two, if there is a violation or something's going on, to take the necessary enforcement action that we need to take.
So I know that when me and Ashley talked about this before, through CRRCS order of protection, it's on paper, but AZ Point you can do online, but they also would get through the courts a paper copy of it. So are we recommending to the clients and the victim to keep the paper copy regardless of if it's on tribal or state or all of the above?
Yeah, you always want to have some sort of proof of your paperwork, whether it be a picture you take on your phone, whether it be a copy you keep in your car, at home, on your person at all times. Whatever it is, whatever you're comfortable with and are able to do, we encourage you to do. A lot of times, as far as the state goes, when it goes to the state courts, when we run people, it'll pop up and it'll say, this is the protected person in the order of protection, this is who the defendant is, and it'll line it all out for us and it'll show that it's still active. But there are times where it gets served and maybe the system doesn't update it right away. But we are able to verify that, yes, we can call, the county here, we can contact our records, or being a small department, we can reach out to the officers that were working the day that it was brought in. We can say, hey, did you serve this OOP? Yeah, I served it. The papers in the office. This is the date and time it was served. Just so that way we can back up what's in the system and then what we actually did, or what the county did, or what the tribal officers did. But there's always a way to verify things. And like I said, we encourage people to keep a picture of it if they can, a copy of it, whatever is the easiest and most feasible for them. I know not everyone can have copies or print out copies, so if all you have is a screenshot of it on your phone or a picture of it on your phone, that's more than enough, because again, we'll go back and do our due diligence and make sure that yes, it is in the system, yes, it is still valid, and we can show proof that it was served.
And onto that also, just make sure that when you have your order of protection, you have the option to go ahead and put protected places on there. So that could be your home, that could be your work, and that could be the school if you put your child on there also. Or certain places that, are important to you and that you want to have it protected. Making sure that the copy of that order is at those places would be very helpful too. So if you have a copy left at your work, so your work knows exactly, it's protected with you, because you don't want that person coming to your work or anything like that. And it's really great for the law enforcement too to have that copy at, certain places too.
So I know earlier we talked about possible fees. So does it cost money to file a protection order?
No, it should not cost any money to go ahead and file an order of protection.
And no cost to serve an OOP either?
No.
So what about for injunction against harassment?
It depends. So an injunction against harassment, if it's just a regular injunction against harassment, which is like stalking, harassment in general, you have to pay a fee for those. The petition, usually here in in Paz County that I know, you don't have to pay a fee in any of the courts, Justice Superior or Tribal. You don't have to pay the fees. To get it served, their fees may be included for those. The only one that does not have a fee is the injunction against harassment if it's a sexual assault that happened.
Got it. Is it possible to apply for a fee waiver?
Yes, you can apply for a fee waiver for anything, honestly, at the courts. You can go ahead and get the paperwork. They have the waivers or deferrals. You just have to fill out that information at the courts and give it back to them.
Awesome. So how long is an order of protection good for?
In Arizona, it's 2 years, actually. It's a whole new law, so 2 years it's valid. Injunction against harassment, it's only 1 year, though.
And is it that the same with tribal court?
Tribal court is only 1 year for order protections.
Got it. So let's say we have a defendant that doesn't agree with the court order. What happens then?
So they can file for their own court date and hearing to actually contest the order protection or the injunction. If that happens, what they'll do is they'll then get a court date, get in contact with the court, schedule a court date, a hearing. They'll go in and explain their side of things. If the judge agrees with the defendant and says, okay, you've shown proof that, this doesn't need to be valid, or that there's something wrong with when it was filed, or if what was being said in the original petition is untrue, the judge can drop the order. At the same time, if someone goes and wants to contest their hearing, but they're not prepared, meaning, someone's upset or they just have an emotional reaction and they go in there and say, oh, well, that's not me, I didn't do that. I've not seen one yet where they've actually dropped it because of, they didn't have proof or anything to show that, there's a reason why this shouldn't be valid. At least in the last, 7 years that I've been here, it's never been based off of just someone going in and saying, they shouldn't have got this, I need you to drop this right now, because people will try that. People will go in there and say, this is lies, this isn't me, but that's all they're going to do. They're just going to go in there and talk. They're not going to actually show proof or say, hey, this is what led up to this, which is why, things happened. They'll just go in there more off of an emotional reaction and let their emotions talk for them. And like I said, I've never seen a judge or a court drop one or the other because someone goes in and just says, hey, this is a lie. Because 9 times out of 10, people that are going and filing for the petitions and getting the injunctions and the orders of protection have proof, and they have something to show, this is why I'm getting it. And the judge is, reading it over, going through every little thing, every little detail, and they're saying, there is a pattern here, there is something wrong here, there is a reason why you need this, I'm going to go ahead and grant this.
And that's why we always ask in the petitions, be as detailed as possible, because you want to make sure that what you're saying is shows that when the judge asks you questions that it's true. And then when you have to go ahead and go to the court hearings and you have a bunch of, contestings, that you have the evidence there with you. And I always want to make sure that everybody knows when you make these incidents, not make these incidents, but write down these incidents and stuff like that. We want to make sure that you are aware that the other party does receive all this information. So all of the pictures, what you write, what you say, the other party is allowed to have that information too. So whatever you give the judge, the other party will go ahead and have that. And we want to make sure that you know that. So that way, if you put any information down, like your home address or your phone number, make sure that you want it confidential. Or if you don't want them to know a certain thing in that incident, how you felt about a certain thing, or you didn't want them to have that picture, don't submit it with that order of protection. But if it comes to the contesting hearing, same thing too. Any evidence that you bring into the court, the other party can have access to that information too. So just be aware of those things, especially in contesting hearings.
And then real quick, to go back to contesting it. So another thing too, sometimes people will write false things or say false things, and it's not more, I'm not talking about intimate relationships right now, but let's say neighbor disputes or friends turned not friends disputes. We've seen that happen before, to where they go and they file an order or an injunction against harassment. They say, this person's bothering me, they did this, they did that. And then the defendant calls us and says, hey, or we serve them, and they go, why am I being served this? And we go, okay, well, this is the process to contest it. Here's what their petition says. You can go ahead and read it, and it'll show, like she was explaining, it'll show in there their petition and what they wrote in there, what they said, what led up to them going and filing for the injunction. And I've had it to where the defendants in these incidents say, that's completely wrong, and they have proof of their own. They go to the court and they say, hey, what he said and what was brought up, or what she said and was brought up, is not at all what happened or how it happened. And they can actually go in there and show proof and show that this probably shouldn't have been granted. And the courts are very open and lenient when it comes to these things. So a lot of times we've seen them where all someone does is they write a 2-paragraph summary of what they believe is the reason why they should get the injunction against harassment. And then we have a defendant that comes in and shows videos and photos and screenshots and has a lot more information and says, this isn't me. This is the proof. This is why I'm here to contest this. And doing that, keeping your documentation for it, protects you on your end too. So whether you feel like you're the one that shouldn't have the injunction against you, or if you're the one getting it against someone, just make sure you have the proof, you have something to back it up. That way, because it's going to come up again, you're going to go to court eventually, someone's going to contest it, you're going to have to show proof, and the more proof you have, the more of a paper trail back to the pictures, screenshots, phone calls, the more you have, the better it is for you on both ends of that injunction against harassment.
So let's say somebody does want to contest the order protection or injunction. Is there a timeline? Do they have a certain amount of time to contest it? How does that work?
They can contest it at any point.
So any time in those 2 years after it's served, they can contest.
They can contest at any point. That's the unfortunate part, is that they can contest it. But you just have to be prepared when that might happen or that might not happen. It really depends. I've had people that don't even show up for the contested hearing or don't even contest it. But you just want to be prepared, because they can contest it at any time, and just be aware of that.
So what if the petitioner after it's been served, what if they want to take it back?
So the petitioner can drop anything at any time. You can, in any case, even any civil case, they can go ahead and drop it. So order protection, injunction against harassment, you can drop it at any point. It doesn't do anything bad against you, but I would really think about that before you drop an order protection or drop an injunction against harassment, especially in order protection, specifically when we work with domestic and sexual violence, because you never know what you're bringing back into your relationship. If you're letting that person back into your relationship, how they're going to react now that they know that the law is no longer protecting you, or if something could happen, they're allowed to be near you. You can't really take them out of a house, or not near them, let them near your work, certain stuff like that. Just be careful about that. Another thing is that credibility. When you go to court, you want to make sure that you're really credible, and that's why we talk about, making sure that you have photos, that you have incidents, that you have paperwork, that you maybe journals, what's going on, phone calls, text messages, all of this information and stuff that you're collecting. You're trying to show to the judge that you're credible, that this is what's really happening. This is what you're really feeling. But when you drop in a civil matter or anything like that, especially in order protection, that's telling the judge in not loud terms, but kind of telling the judge in a way, I don't feel like this person's threatening to me, that he's no longer, I don't fear for my safety anymore. And when you do that, when you try to come back with another order protection, you don't look as credible as before. They'll still try to go ahead and they'll see that it's true and stuff like that, but they'll be wary again to give you that order protection a little bit. So we always ask, really think about what you're letting back into your life if you want to go through those scenarios again, because, you did this for a reason. He was a threat or she was a threat to you and your children or your safety and stuff like that.
And another thing we see too with that, to go off of, where people want to drop it, they'll go and they'll drop it, or to go even further, they'll have an active order protection or injunction against harassment on file, and they'll actually reach out to the defendant and actually try and get the defendant to come to them or hang out with the defendant or see them, and then they'll want to twist it and turn it back around on them and say, oh, well, now things aren't going well. He violated this on this day, or she violated it on this day, or, whoever it is involved in it. So just being mindful of that too, because again, if we show up to a call and you're saying, well, he came and he violated the order, or she came and she violated the order. Okay, well, what led up to that? Oh, well, I told him I wanted to come over, or I told him to come over and hang out or come over and talk. Then it's like, well, at that point, you're encouraging them to violate the order that you originally got against them. So we run into that constantly, especially when it comes to relationships and domestic situations, because, again, people want to believe and think that things will change, and then they don't change, and they fall back into that same cycle, and then they're kind of just stuck in this loop. So we've seen it to where things go well and they're fine, the order gets dropped, and a month, 2 months later, they're back filing for the order again. And then on the other end, we've seen it to where things are going well again, and they have a bad day, they have a bad turn of events, and they go oh, I'm going to call now and say you violated this order. So it's an ongoing cycle, and you just have to really be cognizant of what you're doing and really think about if you're going to get it dropped, if it's for the right reasons, or if you're going to encourage someone to violate the order. You have to understand that if I show up, or if we show up and you want to say, I want to press charges, they violated this order, and you tell me, I invited them over, I told them to come over and do this, or I told them to hang out, or I wanted to do this, I'm going to come up, I'm going to loose you, I'm going to say, well, I'm not going to do that because you encouraged this. You're the one that wanted them to come over. You're the one that told them, hey, come by. So just be really mindful of the decisions you make when it comes to having an active one. And then, again, if you're going to go drop it, just think about what can come from that.
When you're ready to talk, call 888-499-0911. You can also reach out at our website, www.crrcs.com. You can email us at canwetalk@crrcs.com. And you can always follow us on our social medias, Facebook and Instagram.
Cuando estés listo para hablar, nos puedes contactar al número 888-499-0911. También por nuestra página a www.crrcs.com, o los puedes contactar en nuestras páginas sociales en Facebook o Instagram.
Help.
Hope.
Healing.